Now, many of you, and money life represents the financial interest, the monetary interest, the business interest. Economic interests of the state are exempted from disclosure. What constitutes the economic interests of the state is a matter for discussion. Information has been expressly forbidden to be published by any court of law or tribunal, or the disclosure of which may constitute contempt of court. Information, the disclosure which would cause a breach of privilege of Parliament, and information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position of a third party unless the competent authority is satisfied that larger public interest warrants the disclosure of such information. Mind you, there's a proviso here. And information available to a person in his fiduciary capacity, fiduciary relationship, unless the competent authority is satisfied that the larger public interest warrants the disclosure of such information. That means even in a fiduciary capacity. And the fiduciary capacity has been very, very clearly defined. This has been defined very clearly. If I may cite, this is a case of the Supreme Court of India versus Subhash Chandra Agarwal, which was decided in writ petition by Justice Ravindra Bhatt of the Delhi High Court, in which he's gone into details about what a fiduciary relationship means. And here, doctor, patient, lawyer, lawyer, client, and so forth, the usual things, but many other areas, but it is restricted. But a fiduciary relationship also, if the competent authority is satisfied the larger public interest warrants disclosure, it is still to be disclosed. And information received in confidence from a foreign government, information which would impede the process of investigation or apprehension or prosecution of offenders. Mind you, it must impede that process. It is not simply because an FIR has been lodged, therefore you can't get any information on that matter. Now, fortunately, as a result of rulings by the information commissions, FIRs are also all disclosable. The orders of the commissions have been upheld by the courts. Otherwise, even FIRs were not being disclosed, except to the parties concerned. And the police were taking the stand that the law says that. The law says no such thing. The law says that the FIR must be disclosed to the parties, but does not say it can't be disclosed to anybody else. So, this is another area where there has been progress. Cabinet papers, including records of deliberations of the Council of Ministers, secretaries, and other officers, information which relates to personal information, the disclosure which has no relationship to any public activity or material or interest, or which would cause unwarranted invasion of the privacy of the individual. Now, in this case, we have no privacy law in our country. This is perhaps the only law which really talks of protecting the private interest. In a democracy, right of privacy is as much a fundamental right of a citizen as is the right to information. Therefore, the government is now seriously considering bringing a privacy law. But at the same time, it cannot be argued, as the government was known to argue in the initial stages, that if I'm asking information about myself, my annual confidential reports and so on, it was rejected by saying, no, this is private information. This can't be given to you. Private information about myself, which I'm asking for myself? But this was also being done now, of course, as you know, and the Supreme Court has held that ACRs are certainly documents which are disclosable, even if they do not carry adverse remarks to the person who asks for them. And here is another important clause: notwithstanding any of these exemptions or the Official Secrets Act 1923, a public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interests. Now, this brings you to the heart of much of the discussion that has been taking place. If the departments consider that certain information has to be kept secret for certain reasons, and information which is otherwise confidential, they're free to do that. If they've not done it and disclosed it, there is no grounds for then saying that, well, we should amend the law. No. What needs to be done is that the government officials who are dealing with the subject should probably be better trained and better versed in the law. At the same time, this clause also eats into the the sanctity of the Official Secrets Act. Now, I've always held, of course, the Official Secrets Act has no position in a democracy, and particularly a democracy like India. Those of you who've seen the Official Secrets Act seeks to protect the government from the public. Now, in a democracy, you cannot have a law which protects the public from itself, because in a democracy, the public is the government. So this is the weakness of the Official Secrets Act. At the same time, this law takes the matter forward in terms of disclosure of information which should otherwise be considered official secret. Now, copyright is protected, but not of the state. Where practicable, part of a record can be released. So even if part of the record which you are asking for comes under the exemptions which I mentioned, then the remaining part still has to be released. And intelligence and security agencies are exempt, except, mind you, except for cases of corruption and human rights violation. These have to be disclosed under any circumstances. But of course, the Central Information Commission or the State Information Commission, in the case of the states, reserves the right to decide which kind of information of this nature should be disclosed in regard to these organizations. And it is in this area which the Prime Minister had mentioned that the list of such organizations requires review, because there are a number of organizations there which may or may not be necessarily kept exempt. Third-party information. If you find that somebody has asked for information regarding you, you have every right to object to that, provided it does not fall within the leverage of this Act. And an important aspect is that most exempt information is to be released after 20 years, but there are some exceptions. You know that in the US, information is all to be disclosed after 30 years, and every now and then you find the disclosures about what Kissinger said about Mrs. Gandhi and so on and so forth. But in India, all the most ancient form of information is still kept secret and sacrosanct. This partly has alleviated the position. But even this, a case came up before me, Kuldeep Nayyar, regarding the talks between Swaran Singh and Bhutto in the early 60s, wanting to know about the contents of those talks. And when the matter was heard, the file is of course held by the Ministry of External Affairs, and this has not been disclosed at all. Although the US part of it, because there was certain involvement of the US at that time, those have all been disclosed and those are available. The Pakistani side is available. Our side is not available. So our people then came, the Ministry of External Affairs came before us, and they said, well, under their rules, they're supposed to review these top secret files every now and then. So they said they'd reviewed it and they'd taken the decision that it should not be disclosed. Now, who reviewed it? They were asked to produce the deliberations on that. It was a section officer who reviewed it and decided it need not be disclosed. And this was, of course, endorsed by the Deputy Secretary, Joint Secretary, and the Joint Secretary was senior most officer to review it. But what is the reason? Has it been recorded? No reason recorded. So I had then said that a committee be set up to review all these documents, which are more than 20 years old, comprised of the Defense Secretary, the Home Secretary, and the Foreign Secretary. Because, of course, relationships with Pakistan being what they are, one cannot say that everything that concerned the relations between India and Pakistan should all be disclosed. As I have also held in another case, which is on the Indochina War of 1962. But the point is that somebody of a certain seniority, a certain experience, should actually review this. And I don't think that part of the thing has been done at all. And this is also important, that a citizen has the same powers and privileges as a member of parliament in asking questions. And of course, I have mentioned to you about the Official Secrets Act. Penalties, you know of these. I will not spend time on this, but there is immunity from legal action for action taken in good faith. This is important because this brings me back to one of my earlier points. The law specifically asks for access to those below the poverty line. It is one of the few laws which specifically lays down access for those below the poverty line and demands that the persons who are servicing the Act, the government officials, have to assist those below the poverty line in providing the information. There is also a provision for damages. And I think there was an article in the papers today which I read, which said that only 22 cases of damages have so far been awarded by the Central Information Commission, which is probably true. But it is open to all citizens of India. And the public authorities are expected to provide all the information required within 100 days of enactment. Of course, one is the appointment of the PIOs and cataloging, indexing, computerizing, and networking records, which I mentioned to you earlier. But within 120 days of enactment, a whole set of information are updating it every year, 41B, which provides all the basic information regarding the working of that particular department, its programs, its policies. This is what I mean. Had this been done effectively, there would now have been no need to get worried about the quantity of information that is being asked for and the work that the Central Public Information Officer or the State Public Information Officer is saddled with. And publishing all relevant facts while formulating important policies or announcing the decisions which affect the public. This is also reasons for its administrative or quasi-judicial decisions to all the affected persons. And this is particularly so in the DDA. They would take decisions, the Delhi Development Authority, they take decisions to demolish whole colonies, whole neighborhoods. And the persons whose homes had been demolished did not know where they had to go, although the courts had ruled that they have to be given alternative dwellings or alternative places for where they can have their dwellings. But they were never told this. Now, fortunately, that is being done. Of course, the demolitions now are much fewer. And, as I mentioned to you, what the law demands is that this should be provided, this information should be provided suo motu. It can be through websites. It should also be done through other means, publication or writing. And NGOs, of course, have done this, have achieved this in many panchayat areas by getting the panchayats to paint onto their walls all the basic information regarding the functioning of those panchayats. And providing to the Information Commission and raising awareness, educating and training, and compiling and updating regularly. Now, this is not happening. This is, of course, the public awareness part. I'll go through this faster. As I mentioned, train CPIOs and provide relevant training materials, user guide and related matter. The Government of India has programs for training CPIOs. They're stepping up that program now as the pressures mount increasingly. But these are not enough. And it's not enough to just tell them what the law says. It's also important to train them how to operate the law, which also means uploading all the information that they can onto their websites. That, unfortunately, is not being done, although the e-governance plan has now begun to move forward. The e-governance plan is a plan which is being taken up by the Department of Administrative Reforms and Pensions at a scheme of rupees 23,000 crores. It talks of a workflow system which has been devised by the National Information Commission, through which you can make your application, get your response, first appeal and second appeal through the internet system. And it also talks in terms of standardization of procedure. But the records are the ones from which you should access the information. Unfortunately, the computerization of those records is still very slow. And e-governance is the case that I had made before government, is not a true e-governance unless it has a strong element of RTI, and this part, of course, has been accepted by the government. The other instrument through which the RTI can work and should work, and we're talking of the way forward, is by bringing it to the heart of rural India through its panchayat system. You have the Gram Panchayat at the center, scheme information, citizen surveys, fiscal information, the devolution of functions, over-the-counter service, all feed into the panchayat. The panchayat then feeds this to the citizens as groups through their Gram Sabha. The Gram Sabha then feeds this back to the people with a better feedback and accountability, convenience and efficiency of how the system is working, and citizens as individuals can contribute this back to the panchayat. So the panchayat can become the fulcrum through which information flows down to the people and flows back from the people to the government. Is this happening? This is not. Now, Mahatma Gandhi had mentioned the 7 deadly sins. I mentioned them here to see how the right to information will work with this. Wealth without work, science without humanity, pleasure without conscience, religion without sacrifice, knowledge without characters, politics without principle, commerce without morality, that is ethics. The last one says it all, but to be able to access whether any of this is working or whether anyone is guilty of these, one can take recourse to the right to information. The Supreme Court, and we have a representative here, is the organization that can take credit for having declared that the right to information is a fundamental right, and this was the particular judgment in which this was clarified. State of UP versus Raj Narayan, 1975. Many of you will remember this case because politically epoch-making. But in a government of responsibility like ours, where all agents of the public must be responsible for their conduct, there can be but few secrets. The people of this country have a right to know every public act, everything that is done in a public way by their public functionaries. To cover with a veil of secrecy the common routine business is not in the interest of the public. This is Justice Matthew, and thank you very much for listening. But before I conclude, let me just mention, from what I started, the speech of the Prime Minister. I've tried to discuss in detail before you and place before you what the challenges are, what the direction is, and how we can go forward with the RTI, which are the areas where we must focus. It is really in fully implementing the law that we must focus to make it more effective. It is not in thinking of changing the law. And I must say, I was there, as I said, at the Prime Minister's address. I did not get the impression that he was talking in terms of changing the law. He talked in terms of, there were 3 or 4 things that he mentioned. One which he mentioned was that in giving the information, because note sheets and other things are now open to disclosure, it discourages officers from expressing opinion, honest opinion. I have served all my life in the services. I do not think that it will have that effect on a bureaucrat, or should not have that effect on a bureaucrat, unless the bureaucrat has something to hide. So, if one is being honest, I don't see that a person should hesitate or be afraid of the fact of his having been honest becoming known. The second thing which he mentioned was that the information sought should be in the public interest. Now, I have mentioned that the right to information law gives rights to every citizen. Yes, hopefully citizens' individual rights or individual needs also subsume the public interest. The two go together. But you cannot put these into conflict. At the same time, there are certain exemptions, certain things which cannot be given. If you read the law, and I read it out to you, those items which are kept outside the law and are not to be given are those which are harmful to public interest. Therefore, when taking a decision with regard to giving information, one must keep in view that public interest is going to be damaged by giving this information. So therefore, to that extent, it is of course correct, because from there flowed other aspects of his speech which have been unfortunately ignored by the media. where he talked about privacy and the importance of privacy, he also talked about the limitations of privacy, and therefore spoke about the need to define public-private partnerships and the need to access information regarding public-private partnerships, something that I mentioned to you. He talked of the Whistleblowers Act, the means of protecting the citizen who asks for the information, and talked about the fact that this Whistleblowers Act is likely to be passed in the next session of Parliament. So therefore, he talked about strengthening the law. He did not talk about amending it. And when he talked about the difficulties officers face in quantity of information that comes to them, he also talked about the fact that there are in the law provisions which can help to combat that. Combat that in the manner that I mentioned to you, by full implementation and focus of the law. Now you can understand, if a villager is able to access all the information that he requires at his village level, at the panchayat level, then there will be no need for him to go rushing hither, thither to get the information that he needs. And the panchayats can easily access the information if the information is stored in the manner which is laid down in the law and accessible through the internet all across the country. So with these words, I thank you for having given me the time and invited me to come and talk to you, and I look forward to a lively discussion on the subject.